Hello, everyone. So glad to see you here, Fried Green Tomatoes. I hope that you're doing good today. I had found some interesting news I had to share as well shortly. Okay, gotta cut my volume down on my phone. Okay, I always like to start off with the verse Matthew 18, verse 6. But whoso shall offend one of these little ones which believe in me, it were better for him that a millstone were hanged about his neck that he were drowned in the depths of the sea. Copyright disclaimer under Section 107 of the Copyright Act of 1976, allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is the use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use. I hope everyone's having a good day today. I know that it is imperative that we go ahead and make stricter laws concerning pedophiles. Um, I will bring into the effect of a personal case before I go into this, and I think it's sick. He should have had a stricter law. He should have had stricter disciplinaries. I will go ahead without further ado and I will share. I'm embarrassed to say I personally knew this guy right here. Matter of fact, he was an ex boyfriend. I did not know that he was a pedophile. Update: Albertable man pleads guilty to sexual abuse. This was posted July the 29th, 2014. But in mind, before and after I left, I did call FBI to report that he had a lot of child pornographic pictures on his computer, but they did nothing. In Albertville, Alabama, an Albertville man charged with sexual abuse decided to enter a guilty plea before his case had been presented to a grand jury. Albertville police arrested Russell Keith Heron, age 55. At the time, he was 55. This was in 2014. So next year will be another year, so he's right around 64 right now. Mr. Herring was accused and ultimately pled guilty to molesting by touching in the private area a 9-year-old girl, said Assistant District Attorney Jennifer Reynolds. Reynolds says after Herring's first arrest, he found himself in more legal trouble. Then another victim came forward who was a 13-year-old girl. Accused Mr. Herring of actually, when she was sleeping, walking into her house, pulling her pants down, and lifting her shirt up. Last week, Herring decided to enter a guilty plea and was sentenced to 10 years in prison. Now, these children won't have to get on the stand and look in the stranger's eyes and give some of the most intimate details of something that they experienced and had to live with forever. So I'm thankful that Mr. Herring decided to do the right thing and go ahead and plead guilty early and not drag it out in these victims. He also was had some cases against him in Florida, and they got dropped because of the fact that the people did not show up. for the case. I'm pretty good, thank you. I'm glad that you're here. I want to also share a link in the comments, and it's a petition for stricter laws against child molesters. So I will drop this down in the comments right here. And I believe that we do need to make sure to petition for stricter laws. I'm going to go ahead, and I'm proud of what DeSantis is doing in Florida. Now, I will show you that before I get into further back into the other states. Penalty for child rape, defying U.S. Supreme Court ruling. This was updated 3:57 p.m. May the 1st. Thank you, Mr. Ron DeSantis. I'm not going to watch that. Florida Governor Ron DeSantis has signed into law a measure making child rape subject to the death penalty, defying a United States Supreme Court ruling. In Florida, we stand for the protection of children, DeSantis said at a Monday press conference in Brevard County. We think that in the worst of the worst cases, the only appropriate punishment is the ultimate punishment. But in 2008, U.S. Supreme Court justices issued a 5-4 ruling barring states from imposing the death penalty for the rape of a child when the crime does not involve a child's death. Basically, you know what? It does affect the child's life. The rest of it does kill a part of it. Kills a part of the child's soul, heart. So excuse me, what kind of death are you talking about? You know, if you're talking about bodily death, excuse me, no. Court rules that applying the death penalty in such cases would amount to cruel and unusual punishment. So they're saying that it would be cruel punishment to the sex offenders, to the rapist, be cruel and unusual punishment. Cruel, what are they doing to our children? Is that not cruel and unusual? And they keep on doing the crime? DeSantis, though, has said he thinks the current conservative majority U.S. Supreme Court may be willing to revisit the earlier ruling. We think that decision was wrong, he said at the press conference. The bill sets up a precedent to be able to challenge that precedent. Regardless, the signature means Florida taxpayers who are already paying costs for a host of legal fees during DeSantis' tenure look certain to face more. The measure, House Bill 1297, allows a jury by vote of at least 8-4 to recommend a death sentence for sexual battery on a child under the age of 12. It takes effect on October the 1st. It passed out of the legislature with support from both parties in both chambers. Only 3 Democrats and 2 Republicans voted against the legislation in the Senate. I am upset with you all who voted against this legislation. You are true works of art, and that's not in a good way. The piece of crap. I wish we knew who these people were, so these people will not get voted back in to their seats when the next election comes up. Aaron Waite, representing the Florida Association of Criminal Defense Lawyers, has spoken against the legislation, saying courtrooms must be a place for justice and not vengeance. A place for justice? Excuse me. It's not vengeance when you're going and getting justice for this kid. Okay, there's the name right there, y'all. Aaron Waite. Waite, who has also criticized what he called legal issues with the bill, said it could negatively affect violent victims of sex crimes. You're not worried about it negatively affecting victims of sex crimes. You're not wanting to protect the people that this is happening to. That's what it surmounts to do. You're protecting the perpetrators. You are not protecting the children. I'm sorry, everybody, that the system keeps failing our kids. This bill invites a longer, costlier process that the victim and their family will endure, says Waite, who told a legislative committee that he too was a victim of child sexual battery. Well, you know what? You were a victim of it. I'm wondering if you're also being a perpetrator just for the fact that you think it's okay and it's costly to them. But is it not costlier by keeping them in jail the rest of their life and us having to pay for this person the rest of their lives? What about the damage it does to a child? Some children grow up and they cannot even have kids because of what these people do to a child's body. Senate Democratic leader Lauren Book, a victim of child sexual abuse, who founded the advocacy organization Lauren's Kids, said allowing capital punishment to be applied to sex crimes against children could be warranted. Exactly. There's no statute of limitations that a victim suffers. This is a life sentence that is handed down to young children. Very well said, Book. Very well said. DeSantis and the death penalty. This comes as DeSantis touts a law and order focus as he nears an expected presidential run announcement. You can't rest on your laurels if you want to be a law and order state, he said Monday. DeSantis signed two other bills on Monday, both focused on the criminal justice system. There's House Bill 1359, which increases penalties for fentanyl offenses. And there's House Bill 1627, which requires the Florida Supreme Court to develop a uniform statewide bond schedule and adds DUI, manslaughter, fentanyl trafficking, extortion, and written threats to kill to a list of dangerous crimes, allowing for pre-trial detention. Yes, finally, written threats to kill someone. That needs to leave me alone. That pop up. That's trying to put a virus in my system. Okay. With a swipe of a pen, DeSantis made Florida the state with the lowest death penalty threshold in the country. The law makes it so takes only 8 of 12 jury members to recommend it a death sentence. Before death penalties required a unanimous jury decision. The move comes months after a Broward County jury rejected the death penalty for the man who killed 17 people at Parkland's Marjorie Stoneman Douglas High School in 2018. What? You rejected the death penalty for somebody that killed 17 of our kids? It's more costly. Excuse me. It's more costlier keeping the buttholes alive, furnishing they get to breathe while these kids don't have a choice, while these other survivors do not have a choice. Yet you're letting him live. That is so wrong. Florida's law required a unanimous jury decision, and three jurors wanted the life sentence over the death penalty, sparking outcry among those, including the governor, as well as many lawmakers and victims' family members who felt the shooter got off too easy. I should say so. So I'm going to go on back out of here because I am focusing on this other problem. Okay. See, there's where the stricter laws against child molesters. By signing this petition, you can help create stricter laws against child molesters, predators, pedophiles. The mission is to create stricter laws against child predators whose only intention is to hurt children. This is for first time and repeat offenders. Every year, children are victims of kidnappings, violent attacks, sexual abuse, or online predators. Predator statistics show that at least 200 million girls and 100 million boys will be sexually victimized before they reach adulthood. Only 1 in 3 people will report sexual crimes to a trusted adult. Research indicates that 1 in 4 girls and 1 in 6 boys will be sexually abused before adulthood. Sadly, 30 to 40% of these victims are abused by family. Yes, it is. It is in horrible shape, Fried Green. You are right about that. 30 to 40% of these victims are abused by a family member, and 50% are abused by someone outside the family whom they know and trust. Yes, there is a sex offender registry, and with over 747,408 registered sex offenders in the United States, but over 100,000 are lost in the system. These are just a few examples of predator statistics. The law is enacted and enforced on a state by state basis. In 1 year alone, approximately 4,300 child molesters in 15 states were released from confinement. Of the 4,300 child molesters released, approximately 3.3% were rearrested within 3 years for another sex offense against a child. Do you think it's time for child molesters, predators, pedophiles to get more time for the crimes they impose on innocent children? More time in prison may save a child from falling victim to a horrific crime. This will make a difference. It only takes a few seconds to sign a petition, and that's what it says there. And some of the public comments here was like Katie A. from Hanover, Pennsylvania wrote, recently reported an offender for failing to properly register. In the research process, hundreds of organizations and defense lawyers bemoaning the suffering and inconveniences offenders go through. Let's make sure at least that the tier threes aren't treated like martyrs or victims. I will stand up. Excuse me. My allergies and I'll stand up to oppose the strictest registry laws, particularly for abusers of children. And Nellie says, thanks for posting this information and working to advocate and educate the public on this. We have to protect our children from pedophiles at all costs. Then Kelly says, sexual predators are the lowest of the low. These vile beings are incapable of changing. They only get better at lying. As long as they exist, they will remain a threat to others. They show no mercy. They deserve no mercy. And like we had said, there are so many that are not even arrested. And here's some question and answers just on sexual offenders and predators search. This was basically from the state of Florida. This is one of the most it's kind of hard. They're hard on the predators, which is a good thing. Okay. Are sexual offender predators allowed to vote? Please be advised that a registered sex offender, sexual predator, you may be ineligible to vote based on your criminal conviction. If you are ineligible to vote and attempt to register to vote or register to vote, you may be subject to arrest and prosecution for violations. If you are unsure whether you are eligible to register to vote or vote, you should consult with an attorney and seek legal guidance. Next question is: a sexual offender who must register as a sex offender. A sexual offender is an individual who meets one of the more of the following criteria: he or she has been convicted of a qualifying sexual offense in Florida or another jurisdiction. Qualifying adult convictions include sexual misconduct prohibited, sexual misconduct prohibited under that same statute right there, kidnapping where the victim is a minor, false imprisonment where the victim is a minor. Excuse me, why can't they still be convicted whether or not it's a minor or adult? That right there don't, if he kidnaps a grown woman, he needs to pay for it too. Luring or enticing a child where the victim is a minor, human trafficking, and it says VDF or G informer, sexual battery excluding subsection 10, unlawful sexual activity with certain minors. With certain minors? Oh, okay. Unlawful sexual activity with certain minors. Should be all minors, well, don't you think? Unlawful sexual activity with all minors, should it not say? Procuring a person under the age of 18 for prostitution, selling or buying of minors into sex trafficking or prostitution, lewd, lascivious offense committed upon or in the presence of persons less than 16 years of age, video voyeurism of a minor, lewd, lascivious offense committed upon or in the presence of an elderly person or disabled adult, sexual performance by a child pornography penalties, protection of minors, prohibition of certain acts in connection with obscenity, computer pornography, excluding subsection 6, transmission of child pornography by electronic device equipment, transmission of material harmful to a minor by electronic device equipment, selling or buying of minors for portrayal in a visual depiction engaging in sexually explicit conduct. Like, for instance, there was some kids that was like in the room or something, and somebody went ahead and cartooned the kids and did the sexual acts and did a video of the kids doing sexual acts, and they thought that they could get away with that. Instead, it was covering up for what was really going on, and they were just covering it up by using a cartoon character of the child, and that right there is wrong as well. A violation of a similar law of another jurisdiction, federal, military, other state or country. He or she has been released from or is currently serving probation, or an incarceration for a qualifying sex offense listed above on or after October the 1st, 1997, or he or she establishes or maintains a residence, permanent, temporary, or transient in Florida and has a requirement to register or would have a requirement to register as a sexual offender in another jurisdiction, or he or she was educated, I'm getting tongue tied, sorry. He or she was adjudicated delinquent on or after July 1st, 2007 for one of the following offenses and was 14 years of age or older at the time of the offense. Sexual battery, excluding subsection 10. Lewd lascivious battery where the victim is under 12 or the court finds sexual activity by the use of force or coercion. Lewd lascivious molestation, victim under 12 where the court finds molestation involving unclothed genitals. Lewd lascivious molestation, victim under 16 but more than 12 where the court finds use of force or coercion and unclothed genitals. A violation of similar law of another jurisdiction. What is a sexual predator? A sexual predator is an individual who has been convicted of a sexually violent offense as defined in Florida Statute 77521, which may include offenses from another jurisdiction and has a written court order designating the individual a sexual predator or individual who is civilly committed under the Florida Jimmy Rice Sexually Violent Predator Act and has a written court order designating the individual as a sexual predator. What I don't get a lot of times is when they move to another state, a lot of times they do away with them on the registry just because of them moving. But I believe they need to still keep them on the registry so people can look up their record. What are the basic registration obligations of sexual offenders predators? Registrants are required to report to their local sheriff's office for a list of locations and provide information included but not limited to name, date of birth, social security number, race, sex, height and weight, hair and eye color, tattoos or other identifying marks, fingerprints, palm prints, photograph, occupation and place of employment, residential addresses used in transient homeless, vehicle information, all home telephone numbers and cellular telephone numbers, all electronic mail addresses, internet identifiers, and each internet identifier's corresponding website, homepage, or application software name, conviction information, passport information, immigration status documentation, professional license information. This information is a public record unless exempt or confidential pursuant to Chapter 119 FS. Sexual offenders must complete a registration form at their county sheriff's office either twice a year, birth month, and every 6 months thereafter, or 4 times a year, birth month, and every 3 months thereafter, depending upon their offense. For a list of qualifying offenses for quarterly registration, please refer to Florida statute number. All sexual predators, some sexual offenders, and all juveniles, sexual offenders must report 4 times a year. Sexual offenders, predators must update their driver's license or identification card within 48 hours after any change in their residence, permanent, temporarily, or transient or name. Sexual offenders, predators must maintain registration for the duration of their life. All qualifying sexual offenders, sexual predators, and juvenile sexual offenders will be listed on the public registry's website. This is a partial list of responsibility. Please refer to Florida statutes as listed on this page for a complete listing of registration obligations. How often is the Florida Sexual Offender Predator Registry updated? It says right there. It says it's updated on a real time continuous basis as new information is received. But I find that false because I know I have some friends in different states and there's a lot of predators right beside. They live in an apartment right beside a school. Predators are not supposed to be that close to where children go to school. Okay, this is what I was talking about right here. Do out-of-state sex offenders have to register in Florida even if they're only visiting, attending school, or working in Florida? Yes, if an offender or predator is visiting Florida from another state, he or she must report in person to the sheriff's office within 48 hours of establishing a temporary residence. In Florida, he or she is required to report within 48 hours. For example, if it turns out that somebody like Don Wells gets prosecuted for what he had done in Utah with the sisters, if he goes to, and he's a registered sex offender then, and if he goes to Arkansas to work and does not register as a sex offender, he can violate and go to jail for that. Okay. There's a Florida Romeo and Juliet law to register, um, and it said, "How can I receive more information about predators and offenders?" There's also, instead of just here, there's a watchdog.us, and then you type in your address. How do I report information regarding a sexual offender or sexual crime? If you have reason to believe that a sexual crime has occurred, or if you have been a victim of sexual abuse, please immediately contact the local sheriff's office or police department where the crime occurred. If you believe there's any illegal material presented on a website, such as child pornography or child solicitation, please contact your local sheriff's office. Always remember also the number 1-800, the number 4, the letter A, and the word child. They are open 24/7 to take calls anytime anybody goes. And of course, there's people where, and see right here, can a sexual offender predator visit a park, school, or child care center? There are restrictions for offenders convicted of certain crimes. Please refer to Florida statutes. Um, and the list goes on and on and on. But I think it's very important to note. Uh, I'm going to go ahead and with typing into this, I'm going to say strict child sex abuse laws, maybe. Okay. It says it's illegal in every state, but why are they not really doing too much about it? Like, for instance, that guy, had he had prior offenses. He had messed with a girl that was under the age of 12 before. He had messed with somebody in between the ages of 12 to 15. And he actually told me, and I didn't kind of believe him at the point, but he had said that he got out of it that they did something to the child. So they didn't go and report or show up in court. Yes, something terribly has got to change. I'm going to say, go right here and say, which states have strict child. Okay, let's see. There was It said all states have child abuse laws. Let me get this out of the way over here to the right. States have implemented mandatory and permissive reporting laws. Reporters of known or suspected child abuse are subject to immunity. But under some circumstances, they enjoy anonymity as well. Okay, I can understand that when there was an anonymous person that calls and let that be known. In Alabama, the relevant statute defines child abuse as harm or threatened harm or physical abuse, neglect, sexual abuse, sexual exploitation, or emotional mental injury against a child under the age of 18. The same statute contains an exemption for religious reasons for a parent's failure to attain medical help for the child, while a court can still order that any child undergo medical treatments or receive medical attention. What? So the parents, no matter what, if because of their religious background, does not have to get medical attention for the child in the state of Alabama. A parent can lie about it and say it's against my religious beliefs, and it may not be against the religious beliefs. They just don't want to be convicted. How sick. In Alaska, the relevant statute defines child abuse or neglect as a physical injury or neglect, mental injury, sexual abuse, sexual exploitation, or mistreatment of a child under the age of 18 in ways that cause danger to the welfare of the person. The state statute refers to mental injury as well. This type of injury refers to damage done to the emotional well being and intellectual or psychological capacity of a child. The statute also contains an exemption for religious reasons for parents' failure to obtain medical help for the child. This is screwed up. This is very, very screwed up. You mean they do not have to take their child to get medical attention if it goes against their religious rights? What about the child? Is anybody uh, not caring about the child? Where is the protection? They are our most precious things that we are honored to have in our lives. In Arizona, the relevant statute defines child abuse as inflicting or allowing physical abuse, neglect, sexual abuse. What I'm going to start doing is going down to the same statute, see what the bottom one says. The same statute contains an exemption for Christian scientists or unavailability of reasonable resources for a parent's failure to attain medical help for the child. This is sick, y'all. In Arkansas, the same statute also prohibits neglect of a child under the age of 18. The statute contains exemptions for poverty or corporal punishment. What? Are you kidding me? That's in Arkansas, y'all. As a relevant statute defines abuse in many different ways. An example of how the statute defines child abuse is as intentionally, knowingly, or negligently, without cause, inflicting physical abuse. You know whether or not you're abusing your child. You raise your hand up, you do it. Excuse me, you're knowingly going to harm the child when you do this. Neglect, sexual abuse, sexual exploitation, abandonment, or emotional or mental injuries of a child under the age of 18. But they can get away with it because it contains exemptions for poverty or corporal punishment? Excuse me. Dang. In California, the statute contains exemptions for religion, reasonable force, and informed medical decision. It also contains an exemption for neglect based on poverty alone. So you're going to say, well, the family's poor, but we'll let this little child bleed to death. What's wrong with you people? California. If the cultural practice rises to the level of child abuse, the child's or the child's parents' consent cannot be used as an affirmative defense. Belief in the practice as a requirement of the victims or the victim's parents' culture also cannot be used as an affirmative defense. The same statute prohibits the mutilation of children's genitals. Thank you, Colorado. Thank you, thank you, thank you. You are the first ones that actually have good right there. Connecticut. The same statute contains an exemption for Christian Scientists and for neglect that occurs as a result of poverty. Neglect because of a person's poverty. So are you trying to say that it's okay to neglect your child and starve them to death just because you're poor? There's a lot of places that can help your child get food. There's so many places. And in Delaware, the same exemption contains a statute contains an exemption for religious. Oh man. District of Columbia. The same statute also requires people to take reasonable care not to inflict such injuries. Statute contains an exemption for poverty and religion. Do what? You're going right there and you're saying one thing and then you're meaning another. However, you can go ahead and do these actions as long as you're poor or if it's for your religious beliefs. You can go ahead and abuse the child. You can go ahead and exploit your child. You can go ahead and, uh, oh man, this is crazy. In Florida, the same statute also prohibits acts that are likely to cause such harm. The statute contains exceptions for religion or poverty. Crazy people! Exception for corporal punishment specifics that the punishment cannot result in harm to the child. At least it says that the exemption cannot result in harm to the child. But who's going to be the one ascertaining whether it's harming the child or not? Georgia, the same statute contains exemptions for religion. Exemption for corporal punishment indicates that the punishment cannot cause harm to the child. That's in Georgia. In Hawaii, wow, the relevant statute prohibits acts or omissions resulting in the child being harmed or subject to any reasonably foreseeable substantial risk of being harmed with physical abuse, neglect, sexual abuse, sexual exploitation, or emotional or mental injury. The same statute contains no exemptions. Well, they laid down the law. They said no exemptions. You harm our kids, you're in big trouble. Way to go, Hawaii. You deserve applause there. In Idaho, the relevant statute prohibits conduct or omission resulting in physical abuse, neglect, sexual abuse, sexual exploitation, abandonment, or emotional or mental injury. The statute contains an exemption for religion. Okay, the exemption. Let's go ahead and physically abuse our kids. Let's neglect them. Let's sexually abuse them, sexually exploit. Let's abandon our kids. Most or mental injuries. Statute contains an exemption for religion. Dude, what? This is so screwed up, people. Okay, in Illinois. And look at here. The relevant statute prohibits persons from inflicting, causing be inflicted or allowing to be inflicted or creating a substantial risk for committing or allowing to be committed physical abuse, neglect, sexual abuse, sexual exploitation, or emotional or mental injury. The same statute contains exemptions for religion for school attendance and in cases where a proper plan of care has been put into effect and is being practiced. Stop giving exemptions. Stop it. Kids are a commodity. They are gifts from God to us to take care of us. In Indiana, the statute contains exemptions to religion. See right there? I'm gonna have to get my mouse so I can underline, um, so I can really show what I'm doing. Oh man, that went away for a minute. Like, come back. Okay. So in Idaho, the relevant statute, Indiana, the status contains exemptions for religion. See, it's got the relevant statute prohibits act or omission resulting in physical abuse, neglect, sexual abuse, sexual exploitation, abandonment, or emotional or mental injury. Statute contains exemptions for religions. You crazy people. Do y'all not have seen what I put up right here that the Bible actually says right there? But whoso shall offend one of these little ones, which believe in me, it were better for him that a millstone were hanged about his neck, and that he were drowned in the depths of the sea. Excuse me, why are you changing that law? Why are you changing that biblical principle? Iowa, the relevant statute prohibits intentional infliction of physical injury on a child. It includes such injuries that occur as a result of the acts or omissions of a person responsible for taking care of a child. Oh, we know a lot of people that's omitting facts to some things. I'm not going to mention names. When they are intentionally inflicted, mental or emotional injuries are prohibited under the statute. The statute contains an exemption for religion. Intentionally inflicted, excuse me, intentionally inflicted. Anytime you raise a belt and you beat a child and beat a child and beat a child, don't try to come up and say, oh, but it was unintentionally. It's also got right there the statute contains an exemption for religion. In Kansas, the relevant statute prohibits intentional infliction of physical injuries on a child. The same statute also prohibits such injuries that are mental or emotional in nature. The statute contains no exemptions. Good going, Kansas. Kentucky, the relevant statute prohibits harm or threat of harm or infliction or allowance or infliction of physical injury, neglect, sexual abuse, sexual exploitation, abandonment, or emotional or mental injury. The statute contains exceptions for religion, while a court can order that any child receive or undergo medical treatment. Way to go. A court can order the child to receive treatment no matter whether that's accepted from religion or not. In Louisiana, the same statute also prohibits causing damage or injury to the welfare of a child or jeopardizing the safety of children. It also prohibits neglect, including prenatal neglect. Under the statute, a court may order that any child undergo medical treatment. Yes, yes. In Maine, the same statute prohibits sexual abuse or exploitation of children, which also prohibits depriving children of essential needs. It qualifies a caretaker's failure to provide protection from such abuse or neglect as a prohibited act. In Maryland, the statute contains no exemptions. Thank you, Maryland. In Massachusetts, it also not only says about the child's caretaker from engaging in conduct that causes physical or emotional injury to a child or constitutes sexual offense under the laws of Massachusetts. It also prohibits a child's caretaker from engaging in conduct that creates a substantial risk of such injury to the or the occurrence of sexual offenses. The same statute also prohibits sexual contact between a parent, guardian, caretaker, and a child under 18. Thank you, Massachusetts. High five. In Michigan, the same statute contains exceptions for corporal punishment as long as the punishment is reasonable. So you want to give your child corporal punishment? It's okay as long as it's reasonable. Who's going to say what's reasonable or what's not reasonable? In Minnesota, the same statute contains exemptions for religion as well as cultural practices under a few circumstances. For more information, consider reviewing the official text of the statute. So if they go ahead and believe in genital mutilation because of the culture, oh, they can go ahead and do that. Can't harm the child. I thought this is America. Thought we're supposed to protect our kids here. In Mississippi, it also contains an exception for corporal punishment. However, corporal punishment must not result in serious bodily harm. Okay, who's going to implement about serious? Are you just saying serious because if the child's still alive or no broken bones? Who's going to say what's really serious when going to have emotional scars and stuff as well? In Missouri, the statute features no exemptions. Thank you, Missouri. In Montana, the statute features no exemptions. Thank you. In Nebraska, the same statute contains no exemptions. Way to go. Nevada, the same statute contains no exemptions. Thank you. In New Mexico, the relevant statute prohibits knowingly, intentionally, or negligently causing or permitting physical abuse, neglect, sexual abuse, sexual exploitation, or abandonment of children. It also prohibits neglect of children. The same statute contains an exemption for some types of conduct that occur in the course of executing religious rituals, practices, and beliefs. So, as long as you do it in a religious ritual, religious practice, religious beliefs, it's okay to um, knowingly, intentionally cause or permitting physical abuse, neglect, sexual abuse, sexual exploitation, and abandonment of children. Excuse me, that is just wrong. You don't do that and say this is for the betterment. This is the religious. Don't do that. I like the fact that New York does not contain exemptions of any kind. In North Dakota, the statute contains no exemptions. In North Carolina, the statute features no exemptions. Thank you. Okay, in Oklahoma, the same statute contains exemptions for religion or corporal punishment. Y'all are so sick. Y'all are sickos. In Ohio, it features no exemptions. And in Pennsylvania, this is rather lengthy, so I'm going to have to. The relevant statute prohibits physically abusing, neglecting, sexually abusing, sexually exploiting, or emotionally or mentally injuring children. Same statute prohibits failures to intervene in the prohibited activities listed above. The statute contains exemptions for religion or poverty. If there is a question of a child requiring medical assistance or attention within the scope of a possible exemption for religion or poverty, a court can order that any child receive medical attention or assistance regardless of any objection of the child's caretaker. The exemption doesn't apply if the child dies. Okay. Why do you even have any kind of exemption that can make it where then you drew the line too far? Well, then it's too late. The child's dead. What are you going to do then? Rhode Island, the statute features no exemptions. Okay. South Carolina, the statute features no exemptions. South Dakota, the statute features no exemptions. Tennessee, the statute contains no exemptions. Okay, so since I live in Tennessee, the relevant statute prohibits a person from committing or allowing to be committed physical abuse, neglect, sexual abuse, sexual exploitation, or emotional or mental injury of or to children. Do you hear that, the Wells? In Texas, the relevant statute prohibits physically, emotionally, and sexually abusing children. The same statute prohibits neglect. In Texas, the statute features no exemptions. And in Utah, right here, the statute contains exceptions for religion. The relevant statute prohibits harm or threat of harm resulting in physical abuse, neglect, sexual abuse, sexual exploitation, or emotional mental injury. It also prohibits neglect, with the exception of religion, y'all. So they can go ahead and harm a child, threaten a child, physically abuse, neglect, sexual abuse, exploit a child, or mostly or mentally injure a child for the sake of religion. Vermont, the statute contains no exemptions. In Virginia, the statute does not feature any exemptions. Okay, in Washington, oh, this is interesting. The relevant statute prohibits harm to children of health, welfare, or safety resulting from physical abuse, neglect, sexual abuse, or sexual exploitation. The statute contains exceptions for Christian Scientists and corporal punishment. That is not good. Corporal punishment. There's ways to punish a child, but not corporal punishment. Not through physical abuse, neglect, or sexual abuse, or sexual exploitation. No rights whatsoever. Okay, West Virginia, the statute features no exemptions. I am so proud of the states that's not contain exemptions. I am so proud of these states. Okay, let's see what Wyoming, since it's the last but not least. The relevant statute defines child abuse as inflicting or causing a physical or mental injury, harm, or imminent danger to the physical or mental health or welfare of a child. The same statute further requires that the prohibited acts must be intentional, and the statute does not include activities that occur by other or accidental means. Can we understand the accidental means? A lot of people try to say that, um, well, I didn't mean to hit him so hard. You know, that's not accidental. Activities falling within the scope of accidental means include abandonment, excessive, what? The activities falling within the scope of accidental means include abandonment, excessive of unreasonable corporal punishment, malnutrition, intentional or unintentional neglect, or the commission of a sexual offense. Wow. Wow. It falls within accidental, so they would get away with it under this precedent right here. What's the use of having this above for? And they're saying the activities falling within the scope of accidental means include abandonment, excessive or unreasonable corporal punishment, malnutrition, intentional or unintentional neglect, or commission of sexual offense. The statute contains an exemption for religion. Now, I am very upset about this broadcast today. I hope that y'all are upset with this too. I completely agree with you. We need people that care about children in all offices. Some things has got to change. We need to protect our children. The government is saying it's okay to harm our kids, to sexually abuse our kids in some of these states, not all the states. That's why I was making sure to go over the last part, see if they had exemptions or non exemptions. That is so messed up. If they could go ahead and do corporal punishment on our kids for the sake of religion, that is completely messed up. Oh, we need to really pray for our country. We need to really get stricter child sexual abuse laws. We need to get stricter laws towards these people that are going ahead and saying that, and maybe oust these people out who refuse to change the laws to try to help our children. This is sick. That means even teachers or Christian schools, they'll be exempt from being having to pay for their crimes. Look at the case of Gracie Solomon in Tennessee and Grant Solomon in Tennessee. That was a Christian college school. Look at the case of, well, there's another one in Franklin about the teacher of a 3 or 4 year old Sunday school teacher sexually abused a little kid in that church, and yet the judge, the same one, and the Gracie and Grant Solomon thing, who just swept it under the rug and said that the mother cannot sue, told to just forget about the sexual abuse, just get over it. And one of them is even a state senator. Her spouse is a state senator. All right. There's a major problem there. There was another child who was gang raped at a Christian academy in Tennessee, and they did nothing. They would not let anyone prosecute these children that did these actions toward this teenager. This is a mandated state reported, no exceptions. So why is the governor of Tennessee, who's also affiliated with the same school church that judge is going to, and also where that representative, state representative is as well. Even it is well and good that we have these laws, but it's no good when they do not use it to protect our kids. I want to say thank you for coming and God bless y'all. Y'all know I really get heated because I am really mad when they're not doing this to protect our kids. This is senseless. It's well and good to have laws, but if you're not going to enact the laws and you're not going to do anything to protect our children, I think you're just bad as the person who's doing the sexual offense. I think you need to go to jail also when you're going like this and refusing to hear the cases, when you're sweeping them under the rug, when you're not letting the cases be heard in court, when you're a part of these children continue to be victimized, you need to be under the jail cell as well. Maybe we need somebody like DeSantis here in Tennessee that would enable the death penalty. And maybe these people that's perpetrating, that's covering it up, that's keeps letting these children be violated, they need to be locked under the jail cell themselves. So things too. Oh, thank you for being here. I really do appreciate you a lot. So it's good, I guess, that when I get frustrated a little bit, bad, huh? To say thank y'all for coming, and I will say God bless you. And I'm ending this now. And y'all have a great the rest of the day. Take care.